Just hands it from. That's a good one. All right, who do we have? Good morning, Mr. Is it Athey?
Yes, sir.
Mr. Athey, you're charged with assault, bodily injury. You're facing up to a year in jail and or $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present if you cannot afford one. One will be appointed to you, sir.
On January 4th, 2025, officers were dispatched to an assault family call at 72702 West Bay Area Boulevard in Harris County, Texas. Upon arrival, the officers met with the complainant, who stated that his baby mother's boyfriend, the defendant, struck her in the face with a closed fist, causing pain. The complainant stated that his baby mother, Natalie, also has a child with the defendant. The complainant was leaving the apartment complex with the witness, the complainant's girlfriend, when he noticed Natalie parked outside in the driver's seat with the defendant, who was standing outside the passenger side of the vehicle. The complainant and Natalie share custody, and Natalie was supposed to bring back their child earlier that week, but never did. The complainant and the witness approached Natalie to speak through the vehicle's rolled down window. The complainant called the defendant Christy, and the defendant got upset who then walked around the vehicle and struck the complainant with a closed fist, causing the complainant to fall to the ground. The defendant continued to strike the complainant in the face with a closed fist. The defendant then got back into the vehicle and fled the scene. The complainant called 911. The complainant believed that his nose was broken, and the officer saw the nose running.
Right, yeah.
Running
So
from
is
the
this a family
complainant's
member or
nose.
is this just a
Former relationship. So
This is.
Your Honor, yes. So they have a
Yes.
child together, but then the defendant in this case has a child with the same woman. So they were formerly in a relationship.
All right, so no longer a
No
relationship.
longer.
Yeah.
Got it. All right, sir, I'm going to find that there's probable cause to go forward with the case. I'm ordering you as a condition of your bond not to have any contact with this person and not to be in possession of weapons. Do you understand?
yes, sir.
You become a danger to my community. I only have one place for you. If I find that you have any contact with this person, you pick up a new case, have any kind of weapons, I'm going to put you in jail. I will
Yes, sir.
revoke your bond. No more PR bonds. Do you understand?
Yes, sir. So the only thing is, so on the state standard request, it will say CW and family members, but because there are shared custody of
That's with the
children.
MOA.
I
There's no
know,
MOA.
I just want to make sure, he was really concerned because they have like children and all this, so we just want to make sure that he can have access to the children. No problem with the guy, that's
Look, a
whatever.
father obviously should always have access to their kids, right? But don't have any contact with this person. You got to use an intermediary.
Yes, sir.
Right? I get it. Every father should have access to their child, but don't take matters into your own hands because it'll go sideways real quick. You understand? I mean, you ever have any questions? That's why you have a lawyer. He can always answer your questions. Just don't have any weapons. Don't talk to the complaining witness in this case, and that's it.
And Your Honor, I spoke to the complaining witness and he also would like a residency restriction because as he explained, they have a child swap situation where Natalie, the defendant's current girlfriend and baby mama, the baby mama goes to get the child with the complainant and she brings along the defendant, which the complainant expressed to me that since the incident happened on February 17th, another exchange was done where Mr. Athey went along with Natalie. And then he further threatened him saying things such as that he was never going to see his kids again. And he filed a police report for that incident. So he'd want a residency restriction to prevent that from happening again.
That's fine. What'll end up happening is they will then have to go meet somewhere else, at a police station or something along those lines, which.
You understand?
That's how they have to do it.
So how much of you want like a 200-foot residential? Okay, done. If you can follow those conditions. So what'll happen now? Because you have a lawyer, I will waive your appearance. You don't have to waste your time coming to court, but you must stay in touch with counsel. He'll tell you when you have to come back to court. I'll have you sign a receipt. Victoria will have to take a seat. I'm going to get your bond conditions. We'll have you sign it, and then after that, you'll be free to go.
Yes, sir.
Don't be a danger.
Yes, sir.
Don't. All right.
Thank you, Judge.
Matt.
Next judge is page 15. Jefferson, come on up. Thank you, everybody else. So,
We ended up revoking the bond on this, right?
right, so when he called, we're gonna ask him to vote for today.
You were Mr. Jefferson. Mr. Jefferson, you're charged with 2 cases. You're charged with harassment. You're also charged with terroristic threat of a family or household member. On the terroristic threat, you're facing up to a year in jail and or a $4,000 fine. On the harassment, you're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Oh, pause on which one, Your Honor?
are they one and the same?
They're not out of the same transaction, Your Honor.
Okay. I guess start on the harassment, which is the earlier one.
Yes, Judge. On October 15th, 2024, the officer met with the complainant at her residence in Harris County, Texas, regarding a terroristic threat call. The complainant advised the defendant is her ex-boyfriend, who she was living with until April 2024, when she decided to move out. The complainant stated she received a photo of the defendant with a firearm to his head, and after the complainant blocked the defendant, she started receiving multiple emails from him asking for half the rent. When the complainant refused, the defendant sent her a message via email saying, "If I lose this place, I have nothing to lose after that, so I'll be sure to put you there, and that I promise." The complainant went to work and she advised the defendant was at her job and refused to leave despite her requests and stayed outside in his motor vehicle. And then, would you like to hear this?
So the harassment is the text, I'm assuming?
The harassment is the multiple emails, including the message via email saying that the threat.
Okay. All right, go for the terroristic threat. Same complaining witness?
Check, Your Honor. Yes, Judge.
Okay.
So for the terroristic threat on January 2nd, 2025, the officer was dispatched to the residence in Harris County, Texas, in reference to a terroristic threat call. The officer met with the complainant, who stated the defendant messaged her stating she paid her portion of the light bill and the complainant needed to come and pay the other portion. The defendant messaged her twice on TikTok saying the same thing, and the complainant stated via TikTok, if the bill was not paid by the 4th, there will be problems. The complainant received additional messages from a TikTok account with the username account not found, meaning the account was deleted or disabled, and the account stated, "I tried to be respectful. I promise you, if it is not paid, I will put your social security number and personal information on the internet, and I will shoot up that house, starting with your bedroom." The complainant stated she is in fear for her life.
Is there any kind of immediacy to this thing? Do the covers back. The stickers. Your stems.
Your Honor, he specified that prior that if it's not paid by the 4th, there will be problems. And then he's again repeating that state, if it's not paid, that he will shoot up the house. The threat would be, I will shoot up the house.
There's no contingency in a terroristic threat. It's a threat. Here you have an act that's contingent on something else, right? That's not, no. All right, so Mr. Jefferson, I'm going to find there's no probable cause on terroristic threat. However, I am going to find that there's probable cause to go forward on harassment. I'm ordering you as a condition of your bond not to have any contact with the complaining witness in this case. Do you understand?
Yes.
You are also not to be in possession of weapons. If I find that you become a danger to our community, I have one place for you. I will revoke your bond, put you in jail, no more PR bonds. You missed court yesterday. We issued a warrant. I will reinstate your bond today, but this is the only get out of jail free card you get. You miss court again, I will revoke your bond, no more. Do you understand? It is your responsibility to know when to come to court and when to show up. We have given you a lawyer. It is also your responsibility to stay in touch with the lawyer. If he tells me he can't get a hold of you because you're ducking and dodging, likewise, I have one place for you. Do you understand?
Sorry.
So can you file no contact, no weapons, please,
Yes, Judge.
on the harassment?
Yes, Judge.
So what we're going to do now is I'm going to have you sign a reset with Victoria. We'll have you take a seat in the jury box. Do not leave until you sign our bond conditions. Then we'll wait for your lawyer to show up. Mr. Elick, you ready?
Yes, Your Honor, may we approach?
Yeah, of course.
We have an MAJ for Miss Salazar today,
Okay.
and we're kind of talking, I mean, I think last time, y'all were at maybe time served.
And that's where it's thinking.
I'm okay with that. I mean, but that's
She's,
does she want to do it? That's the question. Because last time she
she
didn't want to.
Right, she doesn't have court until March 11th. She has a month of credit. And
What do you want to do? You want to do it? I'm game.
it's her choice.
She has a lot of credit.
She does have a lot of
time. We're willing all the time, sir. She's already.
The thing is that I think last time they wanted me to unset term. And I'm okay with it a lot of times, but in this case, we have just assault after assault after assault. We've already had a couple that have been dismissed, and I can't just continue to do it. Not when you're picking up felony assaults. It's just at some point, we got to say when.
her grandmother wrote an affidavit. I had no part of it. I don't know if you'd be willing to look at it. I know the state said they wouldn't. I mean, I know it's not admissible in rules of evidence, but
I mean,
she led to basically opening the door and hitting her grandma, which I don't even think she knew her grandma was there.
she what?
So the injury to the elderly is what she's undeferred for, what she pled guilty. That case, she was
Against grandma?
was against grandma, and she had an infant, and for whatever reason, there was an argument, and she was like, I'm leaving the house. And grandma was like, no, you're not leaving. And, I think she didn't even know grandma was there. She opened the door and then allegedly hit the grandma. And her grandma wrote an affidavit basically saying, I understand.
And, but I just, nevertheless, we still have, and I don't even know what happened in the felony case. What are they alleging?
So, Your Honor, in that one, officer dispatched an assault. Complainant one is the defendant's grandmother who didn't complain on the case she pled to. Complainant one and defendant got into an argument over care of the defendant's child. The defendant was outside the back door and complainant one was standing in the doorway when the defendant pushed the door hard, throwing complainant one to the ground, causing pain. Complainant one is 80 years old. Officers observed
80.
injuries. 80. Yes, sir. Officers observed injuries on complainant one's arms, or arm. Defendant then left the scene and went to her house where complainant two was, and there was another allegation.
You're lucky that we didn't sustain any, serious. You're 80, you're falling down.
Well, I mean,
Grandfather broke his hip like that.
I mean, she just basically said, she left angry, slammed the door. She didn't realize it was holding the door. I lost balance and fell, and she's basically saying, yeah, she didn't even know.
I don't know.
I
If
know.
you,
She's not
we'll
here.
do the time served, we can do it. Otherwise, we can just go through with the hearing.
Okay.
It's up to you guys.
Let me go, and what time do you think we should start? I know the probation officers and
And I
another.
would probably postpone it to later in the week because I've got him with me now and, just he's sick, so I couldn't take him to school. So, I mean, it would be like later this week.
So tomorrow or Friday?
You want,
Can I offer just something? So could we maybe, and defense, this is up to you, can we maybe bring her out to have her admonished on what's going on? Just see where we're at to try to see if we can get it resolved. If not, then we can go
Sheila?
for the hearing.
I can go talk to her and I don't have a problem with that, but
first, let me go talk. If she's down for taking the time served today, let's just get it done and move on. She can concentrate upstairs. Otherwise,
would it be Thursday or Friday?
and we can go forward on a technical.
Yeah,
That way it doesn't kind of,
yeah.
no.
Well, in the new felony cases have been resolved, so.
Oh, they have?
Yes, Your Honor.
What happened?
There's a deferred, on the injury to the elderly, the other case that was alleged and dismissed as part of the negotiations. So from our perspective, we have a JNS.
So really, it's,
I know.
okay,
I'm just
let me know what.
seeing what I can get, but I'll, yeah.
I understand. It's-
I mean, I feel like I have house money to play with and nothing to lose. Maybe it's a long shot, but
If you need to go with the hearing.
let me just talk with her. And then if we did have a hearing, would it be Thursday or Friday or? Okay,
Monday? Monday.
okay, I'll be back, Your Honor. Thank you. Thank you.
Yeah. What's up, guys?
Good morning, Your Honor.
Hey, good morning.
I'm here on Moses Pena.
Okay.
It is quite old, but we finally figured out the problem. It was an order that was not sent to DPS. So he's going to send that as soon as he leaves. So we kind of put the pieces of the puzzle together.
Anytime you get DPS involved, it takes weeks to months for anything to happen though. So
Sad. It's so sad.
like we're at 190 days. So
I know.
I mean, I can't keep it open for another 3 months waiting for
not.
DPS to do.
No, 30 days max, maybe even 2 weeks. You know,
You want to do, what's the,
as soon as he leaves for DPS, I just want him to get his license reinstated. Because at the time that he had the DWI, the order for the removal of the interlock was not sent either by him or his lawyer. So for all this time, he's.
I don't think that they send an order for removal to interlock to DPS. I don't think it ever, one of those, they don't send those.
We sent, once it's entered, we.
They send, you guys send
Yeah,
order
they do.
removal to
But it
DPS?
wasn't entered till 2 weeks ago, and that case is from 2020.
Right, well, I mean, someone has to come, let
Right.
us know. Usually lawyers at the time when the case is over with, where they
Right.
plead or whatnot, they'll
Ball
get
was
it.
dropped. It wasn't my ball, but I just want to bring this
So
to
what
a
to
resolution.
get done for him to, has he reinstatement fees been paid?
All that's been done. The only thing that they're waiting on, because I even had him, go to DPS, something doesn't fit here. For 5 years, you didn't know your license was suspended. So that's when the lady at DPS said, we're missing this order. So once we finally figured out what was going on here.
You know, the thing is though, is that even if we set it off 2 weeks, it will not reflect as eligible in 2 weeks. I mean, they're going to get it in 2 weeks. For them to enter it into the system, that'll take another 6 to 8 weeks.
Yeah.
Um,
The state has been working with me on this, and I appreciate it, but I understand that there's also a time frame for the
I
court.
mean, we can just keep it open for 6 months waiting for this, especially.
I'm not even asking.
So, I mean, I'll give you 2 to 3 weeks,
Perfect.
you know. Yeah, at that point, I guess we'll come back, see if it's eligible, great. If not, I don't know. We'll have to figure something else. Yeah.
Sounds good.
Okay,
Thank you, Your Honor.
you got it.
Appreciate that.
Take care.
Thank you. May I be excused?
Yes, sir. Come on up.
Okay.
Yes, sir. It's going to be on Robin Parks on docket. So I was speaking with her yesterday. She's having some transportation issues being here today. So I was going to see if we could set her for bond forfeiture, but I am in contact with her.
Good.
So I believe all the discovery is in. We are waiting for an offer, I believe.
Yes, Judge, all discoveries in, and we can look at it and put it offer.
It's 200 days. I don't
Yes,
know
Judge.
why there's not an offer now.
I think it was a 2B for quite a while. Actually, it's not. But it was some kind of.
Factor in the age of the case though, you know, what the age starts when they get on.
Oh, right.
So I'll set it for bond forfeiture for 1 week. If she's not here, I'm revoking a bond. And then you got to be ready to clear a trial at the next setting as well. If you can please put an offer.
Yes, Judge, we'll put one.
All right.
Thank you, Judge.
Got it.
Thanks, Al. Appreciate it.
Sir, you were charged of theft by check. You were facing up to a year in jail and or a $4,000 fine. Probable cause has already been found in this case. Do you have a lawyer today?
No, Your Honor.
I see that we have 2 missed court dates. Is that right?
Judge, the bond paperwork, put him to come to court on the day that, was it, the 21st, which was the first.
I will give you the benefit of the doubt today and I will reinstate your bond, but it's not going to happen again. You ever miss court again, you will end up going to jail. Do you understand? Okay, do you have a lawyer today?
Oh, yeah.
Okay.
I'm pretty sure I know what that case is about. It was
I
a,
don't want to talk about the case. You have the right to remain silent. Exercise that right. Anything you say here, they're going to try to prove guilt for you. You have the ability to hire a lawyer.
yes, Your Honor.
Okay, so we're going to reset your case to give you time to hire a lawyer. So I'll have you go to Victoria, get a reset, and then after that, we'll get you on your way. And when you come back, please have a lawyer.
Yes, sir.
Okay? All right, please.
There's no bond condition.
No, it's a theft by check. Is it to Ann Harris Bennett? Because that's what it looks like they've been used.
Your Honor, is there a cause number for that?
Yeah, sorry, 2533 973. Yeah, it's a registration. I mean, that's what I see nowadays with these theft by checks.
Yes, Judge, registration.
Hey, Alex, we have a ton of trials for next week. Do you know you're ready to go on and who you're not?
Pull up the trial document, quick, Judge, and let you know.
Like maybe 1, 2, 3, 4, 5, 6, 7.
Why's not going?
Yeah, pick one. and move it. I see that you guys filed a motion for continuance.
Yes, we filed on one of the cases.
Have you talked to the defense lawyer, see their position?
Okay.
I don't know. Did you talk to the defense about the continuance?
Your Honor, I sent an email. I haven't heard back from them. My goal was to get them to approach that.
As far as with Jillian, you mean?
Yes.
Okay.
I haven't heard back from her. I asked her if she could come in one day this week to approach. But her issue is that a witness isn't available.
You get one continuance. That's it.
Yes, Your Honor.
So you get one crack. That's it. So if
It's
they come back. and-
notoriously hard to track down and get in court, so I was.
That's okay, but you know, like I said, like if you get a
Yes, and
bond
I
update and then,
being ex parte, Your Honor, I did, when I called them, I made sure that the next day,
Okay.
we did get good dates for them, so.
Got it. Okay, yeah, so let's just, I guess I'll wait for Jillian and we'll see what her reply is and then go from there.
Yes, Your Honor. Thank you.
Are you guys ready on everything else then? All the other trial cases, you ready?
Working on them. I just got this for yesterday.
Yeah. Okay, take your time. No rush. Yeah. Hey, ready? Yeah, come on up. How are you?
How you doing?
Co-counsel's just, he doesn't listen. Other than that, great. How are you?
Well, we're approaching on Torres, Your Honor, Christopher Torres.
Okay, okay. What are we doing?
Well, this is where we're at is, I don't know what your position is on approaching without an agreed rec. That's why I'm approaching.
Okay,
Or how you work that, or do you do that?
yes,
Yeah.
yes, but not, no, I'm gonna time serve on a second.
So,
So,
to give you some background, my client has a prior intoxication assault that he had a probation for. Yeah, in 2013. So he's completed that. And so this is filed as a DWI second. It's a 1-6. It was an accident.
the intoxication assault was the first.
I don't think he has any other criminal history, does
Not, double check. Class C public intoxication 2010, but nothing
he? In
else.
2010? Yeah.
Okay.
So this involved an accident, and the RIP call says there was just some damage and they just wanted to be paid for that. I submitted an insurance document to the state that showed that he had insurance and they were paying. And I think in the RIP call, the guy says he hasn't been out of pocket. And anyway, so the state,
Oh, not even, no deductible or anything like that?
So,
No.
and that's what the complainant stated that the insurance was supposed to be taking care of it. I don't have the information on the deductible. I can get that.
I want to make sure that, I mean, before we do anything, I want to make sure that this person is made whole.
of course,
I don't want to,
and I'm all right with the reset too, Judge. I'm not,
or, you know,
We talked to them on 2/3,
Yes.
and I can follow up today just to see what kind of out of pocket are we looking at? Did insurance take care of it? Which I would agree, they're probably the deductible.
you know, my concern is that we have a prior intox assault and now we have another one. So he's just not getting it. So how do we do that? We need to monitor him for a while to make sure that he understands what's going on and perhaps fix any issues that need to be, you know, potentially fixed. So I would say if he wants to do anything, you know, like do a TRAS, let's set him up for a TRAS and see what it says.
okay.
That's what I'd like to do. So, yeah, let's set him up for a TRAS because I don't, you know, it's concerning the intox
Yeah, I
assault and all
understand.
this. Let's see what a TRAS says and then we can go from there.
Okay, thank you, Your Honor.
Really like to follow the advice because those people usually really nail it on the head as to what we should do.
Okay, thank you, Judge.
Thank you, Aaron.
So let's set it out. Is he here now?
Yeah.
You want to send him now since he's here? We could do a walkthrough and then we can reset it like 2.5 weeks to get results. And then in the interim, that it gives him time to work on the restitution. You okay with that?
Yeah.
All right. Money. On him.
Judge, I'm approaching on Coriel Dixon.
Okay.
The state's offered, instead of doing the full GED course, to do a decision-making class. She's indicated to me that she does want to, you know, keep pursuing the GED stuff. But like we talked about before, she's kind of having to learn all of high school, right?
Sure.
So talk to her about it. She wants to do the class. She's asking for 1 week to get it done.
So the top of page 7.
Yeah. Zero. Yeah, I know. I know. It's okay. Yeah, we'll give you the week for sure.
Thank you, Judge.
Yeah.
How much? 1 week?